you, Innocent. It's a pleasure to meet everyone who is presently on board. I can see a number of other panelists. It's my pleasure to meet you all. I haven't met Claire before, Ituno and Rashida, but I know Cecil very well. So good afternoon, everyone. It's nice being here, and it's nice to join this conversation. It's something that is very critical and important at a time like this. We've heard different things happening in different places and at different times for different reasons, which relate to the value that creative artists are able to derive from their work. Oftentimes, the question around this value comes up when a conflict arises. And in the midst of that crisis, you begin to see different opinions expressed. And more often than not, when you take a look at those opinions and the issues in focus, you may then tend to say that perhaps if there was some guidance from the onset, more people would have been able to take the proper steps to prevent that dispute from arising in the first place. So one of my intentions this afternoon is to look at how creative artists can create, yes, there seems to be a repetition of that word create, but yes, how to create efficient structures around the works that they create. And in this regard, I'm also going to be speaking for the benefit of those who intend and who seek or desire to provide services to creative artists. So in a way, I'm speaking both to creative artists and to lawyers, drawing from my experience as a writer in my past life, so to speak. Well, I guess it's arguable that if you're a writer, you will always be able to write. But there was a time I was largely earning my income from writing, but now I earn my income from writing legal opinions and negotiating agreements. So that's just by the way. So going straight into it, I'm going to start off from the point of knowledge, and that is the awareness of what one has. Now, many creative artists know their work, they know their art, they know their stuff. So, I mean, for instance, there's a trending personality on social media who closes his eyes and draws or makes a drawing with his ears. There are many people who just need to be in a good space, and then they can pound out 10,000 words within 2 hours and to be something so fantastic. There are people who can pick a pencil and make a drawing of anybody in the world, and that is just phenomenal. But beyond the proficiency in the art itself, there's the issue of how well does the artist know the value of what is created or what he is able to create. And that is one of the concerns that I have seen as someone who is right and who is now on the other side as a lawyer and advises people who create things and are involved in various projects. So the first point is everything that is created by one person or by an artist has an intrinsic value that can be legally protected. The simple word for that protection is called copyright. But behind that big word, and I'm going to try to avoid using big words, there are layers of rights available to the creator of any work. Now, the knowledge of what has been created and the rights in what has been created is then essential for the artist for multiple reasons. One is negotiating an immediate return For instance, there is a buyer for an artwork, maybe a painting or something that's been sculpted. The value that the artist places on it will determine how much he or she demands from the prospective buyer. Understood? But then there is also something that attaches to a work of art, which is not about the immediate return or the price to be paid. It's about value to be derived from that artwork on a continual basis over a period of time. So this is particularly useful for writers. So I remember the first time I signed a contract to write for a platform. At the time, I was not yet a lawyer. And so, I was a law student, or perhaps I just finished my degree, but I was yet to proceed to law school where we usually get trained and certified to practice. So I had a few challenges understanding some of the provisions in that contract. And I had to send a contract to a friend who was already practicing at a law firm in Lagos. And then he explained a few things to me. And some of the issues there remain relevant for me till today. And I've seen in a couple of instances where people have had disputes. So one of the rights attached to what you have created, for instance, includes the right of attribution. And by virtue of that right, you may also be able to lay claim to some economic benefits over a period of time, which is what you may then call a royalty. For many people who may not have had an idea of what it means to have produced that work and the value it can continue to give them over a long period of time, they would simply assign or give up the work to anyone who is willing to pay an immediate return for it, without asking further questions about what else may come to them over a period of time. So this is why, for instance, I emphasize or advise my friends that as much as possible, get things documented before agreeing to write for a platform or contribute to a book where, for instance, there is an economic benefit attached to the distribution of that book or the use of that platform. There was an instance or an incident that happened recently where an editor or the publishers, so to speak, or more appropriately put, of a website appeared to have removed the editor without properly or without extensively discussing the plans to remove that editor. And some of the conversations I had with people, they seem to think or assume that by virtue of the fact that the editor had some responsibility for the day-to-day management of the website, he or she had a right to be informed before he or she could be removed. He or she had a right to also determine what appeared on the platform and all of that. He said there's a difference between ownership and control. Ownership ultimately determines the extent of control you can exercise over a work of art or a platform. And in that instance, sometimes ownership and control reside together in one person. In other instances, ownership remains with one person while control is ceded to another person. So where, for instance, the owner of a platform has certain ideas, certain principles, under law, the right of that owner will always be protected ahead of a person to who he or she has ceded control, to the extent that the work itself is what is in focus. The person who has been given control may have some other claims when it comes to the procedure with which it was terminated. But as far as the platform itself is concerned, as far as the work itself is concerned, the law will protect the right of the owner. So the basic idea around copyright and the ability to protect a work then lies in two things: owning something and having that thing in a fixture or in a form where it is seemingly permanent and can be accessed by other persons. So if you have exhibited a great degree of originality in putting some sentences together, you've written many sentences together. So whether it's in the form of a poem or a book or a short story, you have created something, you own it, it is yours. The law automatically recognizes your right to it. Now, when you, for instance, put those sentences together in the form of a book, that book is physical. You have a right to it. So the law will also protect that book. Now, you do not necessarily need to go to any government office or any department office to lay claim to the ownership of what you have created. It is automatically yours. The only instance where, for instance, there might be a need to, or some benefit to registering would be where there is then a dispute. So it makes commercial sense to, for instance, register with a department such as the National Library or any other name that such department might be called in your country. Permanence is also the second attribute. If you have reduced your work into a form where it can be accessed, either as a recording in a tape or in a video that's published, or in any other format, then your right is automatically protected. Now, some of the other rights that you may then have when third parties come into play is, can someone use it and to what extent can they use it? So going back to the example of the writer who is giving his or her work to a website to publish. Because you own the work, your work cannot be taken from you or modified without your consent. You may agree, for instance, that the work should be used on platform A. It doesn't automatically mean that the owner of platform A can also transfer that work to platform B owned by the same person. It doesn't also mean the fact that you've allowed the owner to put the work on platform A that the person can, for instance, put the work without letting everyone know that you wrote that particular work. So those are some of the rights that you have. That's called attribution. So no matter how many times that work is going to be used, there needs to be a connection between the authorization you've given to the owner of the platform and the manner in which the work is used. So for the benefit of both sides, it is usually helpful to have a document that lays out the terms. So you may, for instance, agree that you can reproduce my work on multiple channels that you own, whether in the form of, for instance, allowing someone else to read it and record it as a podcast, or invite a number of people to perform it. But you must recognize that it remains my work, and you must pay me for every time the work is adapted into any of these other formats. Where, for instance, you do not expressly give consent for any adaptation of your work, it will not suffice that someone commissioned you to write a book or write an essay for them. It will not suffice that they convert that essay or book into any other nature of art or any other form of work. as long as you did not expressly give the consent to do that. And for instance, under Nigerian law, that consent may only be given in writing. So the publisher or the owner of a platform cannot say, because the artist has been working with habitually and at different times are somewhat considered to the use of his or her work on other platforms owned by the same person, then this particular work automatically qualifies to be used on other platforms owned by the person or in any other nature that the publisher decides. The court would likely refuse to accept that position. So going to the benefits of ensuring protection for the works created. One of them includes, like I previously mentioned, getting something of value over a long period of time. So to the extent that you have created a work and you have a contract under which the rights, obligations, and the terms by which the parties would relate with that work are expressed and protected, then you can validly claim for benefits in respect of that work for many years. Now, one other thing is where any person other than the person to whom you've given the consent to use your work take steps to make any profit out of that work, you can approach the courts to make a claim against that person. And it doesn't matter if, for instance, the person was not fully aware of who owned the work at the time the person took possession of it. You can, for instance, ask the court to make a calculation of how much profit, how much income the person has derived from that work over a certain period of time, and then get the person to pay that value, or however modification the court may decide upon in respect of that value. So that's what we call account of profit. There are some other rights that also attached to things that are created. So if, for instance, you are a performer, when you perform your poetry and you've done it publicly, everyone saw you do it, no other person can take the same words that you've performed and perform them in another place without getting your permission, because you've already created that work and you have the performer's right to it. If, for instance, you perform the work in a place and someone records you without your knowledge, consent, you can claim against that person for if they decide to make any gain out of that recording, because your right to the work that you have created also includes the right to broadcast it, to reproduce it in any form, to show a part of it in, or incorporate a part of it or the whole of it in another book or any other place. So those are some of the essential issues. Now, for lawyers who are looking to work with creative artists, the question for many would usually be, one, how to identify the issues. Two, where to, for instance, find artists to work with. And maybe some creative artists also have this challenge that, oh, okay, I'd rather just sign the work, the contract myself, or engage with someone without necessarily seeking the help of a lawyer because I don't know any, or I don't even know where to find one. In Nigeria, for instance, there are many people who are now looking into this area of practice. So you can always reach out to a lawyer to make a recommendation if it's not along the lines of that lawyer's expertise. And for lawyers, I mean, there are many platforms and places where artists congregate, and it might just be a good thing to make friends and attend many of these events. So one more thing I was going to address relates to the nature of remedies that will be available. So for instance, where you've seen someone reproduce your work in a book or something, you can, for instance, approach the court to put a stop to every production of that book. You can get what we call an injunction to stop the continuous production, display, broadcast, or however medium the person is using to make your work available to other people without your authorization. You can get monetary compensation for the work. I mean, the value of what has been sold all up until the time when you approach the court and got the court to stop that person. You can also get some other claims for damages. I mean, like compensation for the gains you would have made if that person had not exploited your work, and thereby preventing you from making your work earn an income for you. So in different situations, in different circumstances, there might be few peculiarities to consider, but and for the sake of those peculiarities, you might just need to get a lawyer to look at the issue specifically and then guide you on how to proceed. Having said all of this, it may be helpful to just note that there are some instances where someone might be able to use a bit or some part of your work, even though you generally have a right to your work, and prevent other people from using it without your permission. There are some instances that the law may permit other people to take some of your work, and that's what you might have heard some people call fair dealing. But that concept is only helpful to anybody who has used the work, where, for instance, they've used it for educational purpose or just to make a commentary, critique, review, and they only took an extent that is reasonably necessary to achieve that particular purpose of education, commentary, critique, and sometimes comedy. So it is not enough for someone to take 2 chapters out of your work and include it in a review for the benefit of people who are going to read that review and simply say he or she did it simply because she wanted to do a criticism. The court may want to ask that, was it really necessary to include up to two chapters if, for instance, a reference to 1 or 2 sentences might have sufficed? So, however the case is, when, for instance, you feel aggrieved that someone might have infringed on your right, or, okay, let's not use big words. If you feel that someone might have overstepped their bounds in relation to what you own and produce, it may just be good to seek counsel and seek advice from a lawyer to see what extent you might be able to make a claim under those circumstances. So I think I'll stop here and allow any questions that may be available to be asked so that I can then respond to them.
Thank you very much, Tobi. Thank you very much for your time. Thank you very much for your presentation. So I remember clearly the case you cited earlier, the one about the editor who was dislodged from his position. I remember that clearly. But what do you say I mean, a lot of times, some of these negotiations happen, like basically they're verbal exchanges. It's possible that editor, for example, had a different role with the publishing house over time um, before being promoted to the role of editor and didn't get to sign a new contract but had a verbal agreement over control. So, and then there have been multiple cases like that. Even I had a call with you last week about a similar case where it was via email, and then when it got to the financial conversation, it became a phone call. So what do you say about things like that? How do you protect your interests after the deal has been made and it was made via verbal communication? Is there any protection in the law for verbal contracts?
Okay, so first rule is try to get everything written. But then, where for some reason, some critical essential parts are written and then some additional parts are not reduced into writing, you might be able to lay a claim for protection in respect of those parts that were not written based on the conduct that has been established in relation to what was written. So in the two instances you cited, for instance, I'll start with the second one, where a contract exists about providing services of a particular type. And the remedy or the remuneration rather to be paid in respect of services were not documented. It is possible that where that matter goes before a court, the court may take a reasonable man's view or adopt a test of a reasonable man in that position. So where, for instance, the person who provided the services is able to show that for this type of work, these are the kind of charges that are ordinarily applicable. And when we had the conversation, these were the same type of charges we agreed upon. So it doesn't necessarily matter that I'm unable to show the proof that we agreed upon those fees. This is what ordinarily obtains. It is dicey, of course, but with sufficient support in form of, for instance, if you're able to bring to the court other documents where similar rates were agreed upon, the court might be kind enough to lean in your favor. But ordinarily, I advise that from the beginning to the end, anything that would become binding between the two sides should be reduced into writing. And even when there's going to be any variation or change in the terms agreed, it should also be done in writing. You can do in writing by email as well. It doesn't have to be done in terms of just the original agreement itself. So that's why, for instance, when I draft agreements of for people, I tend to include that changes will be made in writing, and that writing includes electronic mail. So if you're able to produce an email that shows that, oh, we agreed this part to change what was initially agreed, then it will suffice. For the person who was working with an organization and have worked in different roles before he became an editor. Now, I was trying to make a distinction between ownership and control. Being an editor is still about control, not ownership of the platform. The publisher owns the platform, except where the publisher doubles as the editor. The other people who might exercise ownership are the writers. So the writer has a right to the work. And in fact, the editor in certain instances double as a writer. So the editor has a right to what he has written as well, and can even enforce that right against the publisher, where the publisher, for instance, changes the expressions in the editor's work, which the editor wrote, to express things that the editor did not intend. So that more or less means that the publisher is now taking over the editor's work. So in that instance, there needs to be some demarcation of the rights of each person in relation to the position where they stand at each point in time. So it doesn't matter that you started with an organization as a writer and then moved over to an editor, that any right that attaches to the position you are in now automatically overrides any other obligation that you might have as someone in that particular position. So as a publisher, you own your platform. You can decide to publish your platform. You can decide to not own it anymore and decide to delete it or something. But the works on that site do not belong to you because they belong to the people who did, unless there is a contract in writing, an agreement in writing, where the ownership in those works have been transferred to you, especially where you commission people to write and you paid them for it, and you included in that contract that upon delivery of the work to you, that their rights to the work cease, and they agreed to that in writing, then that's fine. So I hope that addresses your concern. As for the question about whether there are pro bono initiatives for artists, I do not know of many in Nigeria. However, I know that for many of us as lawyers who relate with our friends in the art sector, we generally do a lot of pro bono work because more often than not, our friends tend to make us or convince us that, oh, this is just a small thing. This is just the beginning. Don't worry, I would engage you when a bigger thing comes, and tend to advise for free. But in terms of an institutional approach to offering pro bono services to artists, I'm not so sure. Nonetheless, I know for a number of organizations that support artworks or art initiatives, okay, I'm not going to mention names, but there are some institutes and foundations. They typically have lawyers who work with them who can then provide services to the participants of various initiatives put together by those foundations and institutes. So a creative artist might be able to benefit from free legal services through those arrangements.
All right, Tobi, thank you. Thank you very much. But I have just one more question. I just want to put you on the spot before we wrap up your session. Just quickly put you on the spot. I introduced you earlier as the chairman governing body of Nigerian Bar Association Young Lawyers. It's a long title. So I want to put you on the spot. Like you just said, there seem to be no ready-made pro bono services or ready-made arrangements and agreements that exist, except for friend to friend, like the way I use you from time to time with my contracts. But what in your capacity can you or are you trying to do in that regards? Being someone who is an artist in all regards, you're a writer too. I mean, I know I make jokes about this, but I know you're a writer, you're an artist in every regard of it. Being an artist and also being a lawyer who holds such a position, what are you doing, or what can you do with your position, or what possibilities exist in the near future?
Okay, so to a large extent, the things I foresee are collaborations, especially institutional collaborations. We have, for instance, not been approached yet by any institute to provide some form of free legal service to them. But it's something we are willing to consider, where, for instance, we're able to establish some benefit down the line for the lawyers who will be participating in that initiative as well. I mean, lawyers earn a living from providing services, and there's only an extent to which you can provide free services for it. Many people without getting paid and being able to survive or remain liquid in terms of your own, looking at your own self. So many people may not ordinarily jump at the prospect of offering free legal services until we're able to structure some benefit down the line as well. I mean, Nigeria is not particularly a very rich country where everyone is able to earn significantly well enough from doing a few things, such that they can then provide pro bono services a whole lot. For many lawyers, in every brief that comes their way is just to augment their income. So that's the challenge. But then um, the conversations come to the table. I would always lend my weight and see what can come out of it. I've negotiated some pro bono arrangements for some criminal matters before, because there were certain things I could help the. Oh, okay. I just had a power cut here. Sorry, this is Nigeria. So there were certain benefits I could see down the line for the lawyers who were going to participate in the initiative. For instance, training and access to certain research tools which they would not ordinarily be able to afford. And that organization was going to facilitate that. So it's a conversation I'm willing to have in my capacity as the chairman of the Young Lawyers Forum.
Okay, I'm very sure in the next couple of months I'm going to take you up on that conversation.
Absolutely. That's
yeah,
fine.
and we'll try and hopefully the drill and YLF would be able to reach an agreement to do something else on that. Thank you so much, Tobi. There are more questions actually coming in, and if you have any question for Tobi, please you can reach out to us at attention@thedrill.org, and we'll make sure that the questions get across to him and get the answers get across to you. So yeah, you definitely get more questions from us with regards to the law and arts in Africa,
Okay, so
especially.
let me just add something. Based on Rashida's comment recommending barefoot law, that just drew my attention to the fact that, okay, fine, why we do not necessarily have many, or I do not necessarily know of any arrangement for pro bono directly from lawyers to artists. Many lawyers actually provide free legal advice, so to speak, through writing. So there are a number of websites where you can easily find useful resource that might be able to guide you in providing some self-help to yourself. But ultimately, we always advise that if you're going to take a step based on legal advice you get from online, you might as well just speak to a lawyer directly. But then a lot of websites, including I own one of such websites called Lawyered. And if you go on Lawyered, as well as a number of other websites, Legal Ninja, and some other ones, you will find helpful interpretations of provisions of the copyright law and other provisions relating to intellectual property rights.
So it's from Itunu, and they've just mentioned, so I have a question for Tobi. It is about policies on art that is being affected by other policies in law, e.g. the artistry of being a drag queen and the policy against the LGBT plus community in Nigeria. What is the best advice to give to someone who chooses this form of artistry?
Okay, so that's a bit dicey. So I'm just going to say that's a little bit dicey, and caution may be required, understandably. But to a large extent, the courts have often protected the right of artists to project or portray what obtains in the society. Now, more often than not, you would see that the court will lean to the side of an artist who is narrating or depicting any type of personalities in the community. So if, for instance, a drag queen or any other of the persons who fall within the categorization of LGBTQ plus is being depicted in a work of art, I believe that where any state agents attempt to maybe prevent the performance of that art or the broadcast of a work of art that reflects that depiction, I think and I believe that the court will likely prevent the state agents from doing so, largely because it is an expression of art, and an expression of art that also leans towards the rights guaranteed by the Constitution in terms of freedom of expression. So I do not think a work of art can be entirely prevented from being broadcast in that manner. That is not to say that, I mean, for instance, we know there's a law in Nigeria that prevents persons from openly identifying as gay and promoting same-sex marriage and the likes. The argument may then be made that is this work of art promoting something that is against the law. I do not think that where, for instance, the work of art is objective, does not make it a prescription that persons who are observing, watching, or attending, or doing anything of such where the work is being broadcast, shown, must toe a particular line where it is not commanding them or prescribing to them that this is the lifestyle to follow. I think the court will likely still protect the right of expression in that situation.